Get the meeting started. Before we get into the dog conversation, I just want to point out, I think each of the board members, a copy of the comprehensive plan survey for Wyoming County. There's also some copies on the back table. If they're looking on that, you can either fill out the paperwork and send it in, or you can do the survey online. There's also a poster by the door out there with the QR code. If you want to scan that, you can do that as well. Okay, all right. We have draft 8, which incorporates changes that we had in draft 7 following our last meeting, which I think went really well. We got some good input, and made some changes. There's copies of draft 8 on the back table as well, if you want to go through it. And, Eli, if you want to go through and highlight the changes that were made.
Sure. Just so I'm aware, are you guys looking at the red line copy or the clean copy? If it's red line, it would have a revision right in that first paragraph.
I have both.
Okay, so just so everyone's aware, I'm going to be going off of the red line copy.
Okay.
Again, not nearly as many changes to draft 8 as there were between draft 6s and 7. So I'm just going to go through them one by one and kind of hit those really quick. Section 1, purpose, in the first sentence there, we did change the language from has created to may create. Let's see. Moving on to the definitions in section 4. The first change we made to that, at least in my copy, is on page 4, the definition of kennel. That was just to clarify that 6-dog limit, as opposed to the previous 4 that we had. In recreation area and in run at large, I just kind of made a dictation change. I took out the run at large shall mean language because run at large is right in front of that sentence. Section 5, restrictions, subsection B, where we incorporate the terms of Attica's dog barking law. As we discussed at our last meeting, those limits have been increased from 5 minutes during what I would call nighttime hours between 10 p.m. and 8 a.m. And we also changed it from 15 to 30 minutes between the hours of 8 a.m. and 10 p.m. Section 5, subsection J, we struck the last sentence from there. It previously had read, any dog that has been deemed or designated as dangerous shall not be permitted off the property of the owner or the owner's premises except as otherwise permitted by law. While on the owner's premises, the dangerous dog shall be confined at all times either indoors or within a securely enclosed location in all occupied or dog run, which meets the definition of enclosure as defined herein. We took that last part out. That kind of, just to be clear, we took off the sentence that said, while on the owner's premises, the dog shall be confined at all times, either indoors or within a securely enclosed, or securely enclosed within a locked pen. Reason being that essentially usurps the county judge's authority, because mandating secure permanent confinement is a remedy under agriculture and markets law that we did incorporate into here. That provision is essentially usurping the judge's authority, so we just took that one sentence out. There were no changes to section 6. No changes to section 7 or 8. Section 9B, that's for the reporting requirements for dangerous dogs. I just amended that a little bit to, we've enumerated the emergency services personnel that have to be notified. But I also clarified that it's the dog owner's responsibility to report the dangerous dogs to the town clerk, and then it's the town clerk's responsibility to forward those reports to those emergency services. So that was just clarified in that. No changes to sections 10 or 11, no changes to 12. Section 13,
I have a question.
sure.
12, section 12 has got paragraph E completely lined out. Is that a correction or is that?
Section 12,
Section 12 complaint, and then you turn it over and it's got B, but then it has, maybe, I printed out,
You might have the, I think the last one is C as well.
let me look at it. Okay, you just read that? Okay.
'Cause
Never mind.
just to be clear, for 12, I only have A, B, and C.
Okay.
Is that what the rest of the board? Okay.
Yeah.
Penalties for offenses, the only changes to that were in subsection C. Like we discussed last time, all of the offenses have been changed to violations instead of misdemeanors. The jail time was removed from those, except for subsection 7, which is if the dog has already been deemed dangerous and then bites a person or other animal, that would be the only situation that would be, it would be an unclassified misdemeanor, $1,500 to $3,000 on the fine. And
Is that
then,
in Ag and Markets?
yes, I believe that we took that straight from Ag and Markets, I can just confirm that. Again, it's a little bit different. Yeah, so Ag and Market says the owner of a dog who through any act or omission negligently permits his or her dog which had previously been determined to be dangerous to bite a person causing serious physical injury shall be guilty of a misdemeanor punishable by a fine of not more than $3,000 or by imprisonment not to exceed 90 days, or both, such fine and imprisonment in addition to any other applicable penalties. So it is a little bit different because we do have, that only applies to people, but under our law, we apply that same standard to animals as well. Rest of the law is the same. Those were the only changes we made since we had our last workshop last month.
I have a question over here.
Question. When you're talking about, well, let me just see, it would be section 5, paragraph H. The only question I have is,
We are, and I'll let you ask the question, Debbie, but just to be clear, we are, like we talked about at the last meeting, we are still going to try and revise that last sentence about compliance with the kennel law because we still don't have a kennel law yet.
okay,
Depending on how the board feels, next month might be tough for a public hearing just because it's budget season, but we should be able to have the kennel law ready for the board to at least take a look at and possibly schedule a public not have the public hearing in November, but schedule it in November, and we may be able to do a public hearing on both the dog law and kennel law at the December meeting.
okay.
But what's your
Yeah.
question?
Yeah, my question was what the requirements were for a special use permit.
Yeah, we're still working that out.
Okay.
That's gonna be in the kennel law.
Okay. The other question I had is, well, it's not really a question. I know the Ag and Markets law, both in the, well, New York State and the Assembly and the House have at least approved in the Assembly and the House, an update to their dog law, which is now in committee. It hasn't been approved yet.
That is correct.
Okay. And, my understanding is if and when that does get approved, which I have a feeling it's going to, it mentions in the, previously, it had an exemption for folks that were breeders, if you had so many dogs that were born and raised on your residential premises.
These are the hobby breeders you mentioned last time?
Yes,
Yep.
right, okay. And my understanding is that if this new bill passes, that there's no exemption for hobby breeders. It's, they're being lumped together with commercial breeders where you have to get an inspection and XYZ and XYZ, okay? If that does get approved, will that have any effect on this?
I'll be honest with you, I haven't delved too deeply into the substance of that.
Okay.
There's just not enough time for me to spend my time learning about laws that have not yet been passed. I have kind of, I'm not as familiar with them as I am Ag and Markets 123, but I've looked at them, I don't know the substance of it off the top of my head. To the extent that it created any major inconsistencies with our law, we can deal with that by amendment. If we just have to incorporate those changes into this, we can do that. But as far as a difference for hobby breeders, typically the way that it works, if the state mandates a law, you know, a local municipality under what's called the municipal home rule law can vary from that, but they can't lessen any of the protections, they can only strengthen them.
Right.
So I'd have to take a look at what those restrictions are gonna say specifically for breeders. You know, if there's not an exemption for hobby breeders, unless they specifically say that there shall not be an exemption, theoretically the town could put an exemption in their law as long as they're not prohibited from doing so under the new law, the state law.
I forget what the wording is, but, I know all the dog clubs in New York State, and there's a New York State Dog Alliance, if that's the correct term for this group. The dog clubs, including the AKC, are very concerned about that passing. I know the AKC has sent around a position paper with regard to that.
In opposition or support?
Opposition, not having an exemption for hobby breeders. So, you know, be that as it may, I don't know what effect, you know, you would anticipate until, you know, it passes or whatever with this. I'd be glad to send you a copy of the AKC's position paper, as well as any other information that I have from, you know, some of the local dog clubs.
I'd be happy to read that.
Yeah, I'll email it to you, but like I say, my only question was, and it's probably too premature, is, you know, would that have an effect on this? But since it's, you know, it hasn't been passed yet, it's sort of putting cart before a horse, but I just wanted to mention it.
I have a question.
Sure.
On page 3, on the definition of enclosures, it seems like enclosures in here already define an enclosure for a dangerous dog. Do we need to have enclosures as a definition for everything?
I think that you want one because when you define it, it takes that ambiguity away. Again, I mean, it's not gonna be, we wanted to define that for that one subdivision in 5 for that sentence that we struck. But in the event that a judge does order permanent confinement, you wanna have a definition for what the
Right, but we
enclosure
want
has to be.
enclosures for dangerous dogs and then enclosures for no.
An enclosure is an enclosure.
Okay.
So if my dog on 20 acres is walking, running around, visiting the horses and everything, that's a no-no?
Well, that would be more of a dog at large issue. What we removed from this was for, under the previous draft, it read that any dog that was deemed dangerous had to be
Yeah, I read
confined in an enclosure.
it. Yeah, I read
We
it.
took that out, because that essentially usurps the town judge's position and authority in issuing a fine if he, a remedy rather, if he does deem a dog dangerous. So we took that out, but the town justice does still have the authority to say, I have issued a finding that your dog is dangerous, I'm going to issue, secure humane confinement. It has to be enclosed in an enclosure that meets this definition. Which is why you still wanna have the definition in the law.
Can you say your question?
It does matter, it does matter. This is the place where you speak up, say
My
it again.
question was this, I live on 20 acres. I
Oh,
have
okay.
dogs.
I thought you said 28, okay.
28 acres. I live rural, this isn't the city.
But
You're
you're talking
talking
about the
about on your own
dogs on your
property.
property.
Is
Right,
it no
I'm
problem?
talking about on my own property.
Oh, yeah.
My dog is running around out there with me.
Oh, yeah, that's fine.
He just said that was an,
But he just
said
said that was
Dog
an
at
issue.
large issue, is what I heard.
That's what
I
he said.
thought she was saying, went and like visited the horses on some, if it's on your property,
I
You
heard
thought you meant to somebody
volunteer
else's property.
property is
My property.
horses, yeah,
Then that's fine.
okay.
So a dog is allowed to run free on their property?
Yeah.
Sure.
Okay, no, it does not need to be fenced in.
Not unless it's deemed dangerous and the judge says otherwise.
Okay, now my other question is, where does against all odds fit into this? They are considered a sanctuary. They do have dangerous dogs that were deemed dangerous at one point in time. And
But
they,
when they came to New York, they weren't anymore.
we
If they
don't-
were, if they came from out of
We don't
state.
have any out-of-state dogs at Against All Odds.
Okay.
right, because their huge thing was Bandit. Bandit was in the town of Lancaster. He was deemed a dangerous dog. Since Matt Albert at Against All Odds, since he's been under his care, there have been absolutely no issues whatsoever in the 2.5 years that Bandit has been there. So my question is, seeing that Against All Odds is an animal sanctuary, they've operated for over 5 years, has provided immense benefit to both animals and residents. And animals under their care should be granted the freedom to live as dogs, which naturally includes barking. They're not nuisance animals. They're part of the sanctuary environment and should be exempt from the same standards that apply to the typical residential settings. Where does the board stand on that?
Well, we don't know what kind of dogs he has because he doesn't register.
I can't speak for him, but
Well, I know that.
According to our records, he doesn't have any dangerous dogs. Because he hasn't filed any paperwork that saying that he has.
So, I'm sorry, you're saying his dog should be exempt from this law, is that what you're asking?
well, because they're sanctuary dogs. So I wanted to know, because that he runs a sanctuary,
Mhm.
which is not a residence, it's a sanctuary. I feel like they should be exempt from whatever it is that you guys are doing here.
In other words, trying to keep them locked up at all times.
They
that's not
shouldn't
the
be.
law.
No, that's
That's
not,
That's out of the law, though.
that's not what it's saying.
I'm not saying that it wasn't, but that has been removed, that they have to be confined. They do
Okay,
still
so
have,
you did remove that.
they do still have to remain
Yeah, that was
on
one of
the owner's property, but they do not have to be in an enclosure.
Okay, or a kennel.
Correct. Well, yes, correct.
Wait, they
Th-
do
there's-
not
we're
have to be
gonna-
on a kennel?
We're gonna do a separate law for for kenneling, but dangerous dogs specifically, as the law is right now, they just have to be on the owner's property, they do not have to be in an enclosure.
Okay.
question. Dangerous dog, if the dog is on the owner's property, and let's assume it's a big wooded area, does that wooded area, and for the dog to be loose on the owner's property, does that wooded area have to be totally enclosed?
It does not,
If the dog is considered a dangerous dog?
it does not. It's still private property.
Right.
But isn't there, if it's deemed dangerous, isn't there something that the judge says, this rules what happens with this dog? I would think.
Correct, and again, if the judge orders secure permanent confinement, it's a different story. But again, that's not a mandate of the law, that is a discretionary decision of the judge under Ag and Markets that we've incorporated locally.
Sorry.
Okay.
I guess my issue is, if you have a dog that's been, and this doesn't relate to anybody, okay, this is just my own thinking about all this, because I don't know all the details of what's been going on, I haven't been involved. But if you have a dog that's been deemed dangerous by, the court system, and it's running loose on your property with, let's say you have, I don't know, I've got 3.25 acres. I don't have a dangerous dog, but let's assume. It's running loose on your property, 3.5 acres. it would seem to me that that should be fenced in, because you can have other animals and you can have people or whatever come onto your property in the woods, and I know that would be trespassing. But,
There you go.
what would happen if indeed that dog attacked somebody that was trespassing?
Trespassing.
Yeah.
They get trespassed.
I got it, okay?
Any dog can attack anybody on your property. I think what is getting misconstrued here, the word dangerous is oftentimes a mischaracterization of these dogs. That's just
It's not, it's illegal, it's a
definition.
legal term.
Right, but a dog can be deemed dangerous for biting another animal, not even biting a human. And there have been dogs who have nipped humans, who have nipped other animals, that don't get that dangerous designation. So I know people hear the word dangerous and they think like, oh my gosh, this is really spooky. But you have to remember that this is something that occurs much more often than what we're talking about in the isolation of Against All Odds. I want to go back to section 13, part C, subsection 7.
Well, I didn't touch the first section you
Oh,
cited.
section 13, penalties for offenses, subsection C. And then under C, number 7. I do want to highlight again for the record that this is not what's stated in Ag and Markets directly. If a dog is to bite a person or another animal, that's a civil claim. That does not qualify for a misdemeanor offense. If that was true, nobody in their right mind would run a sanctuary or a rescue knowing that they could possibly get a misdemeanor charge against them, because dogs bite. It happens. It happens for a wide variety of circumstances, and most of the time, about 90% of the time, a dog bites because they were put into a situation at the fault of the person in charge, not because the dog is innately aggressive.
I mean, just to be clear, Ag and Market says it's a misdemeanor if a dog which has been previously deemed dangerous bites a person and causes serious physical injury. So there are misdemeanors considered under agriculture and markets. The difference in our law in agriculture and markets is that we've expanded that to include not just people, but to include animals and include physical injury in addition to serious physical injury. Everything else is pretty much verbatim from Ag and Markets, except for that one subsection. We did differ the penalties a little bit. We went over it in a bit more detail at our last workshop. The Ag and Markets does a pretty darn good job with their dangerous dog statute, but it's not perfect in that there's gaps in the fining structure. So essentially what we had discussed and what we went with is we've tiered the seriousness of the violation, if you will, where we've treated people and service dogs, guide dogs, hearing dogs at a higher level of importance than other companion animals, farm animals, domestic animals. So what we've done is essentially, and then we've kind of further tiered that into the degree of injury that's caused by the alleged bite. So a bite to a companion animal, farm animal, or domestic animal that only causes physical injury is treated slightly less seriously than a bite to a person, service animal, guide dog, or hearing dog that results in physical injury. And then it's kind of that same structure for, for serious physical injury and then for death. And then what we had discussed at the last meeting is the only thing that we wanted to consider to be a misdemeanor is a bite by a dog that had already been considered that had already been deemed dangerous by a court of competent jurisdiction in New York. And then what we did is we took that, the fine structure out of Ag and Markets law and put that in there.
explain the reasoning behind why we decided to do this. It was because we're not trying to punish the dogs.
Right.
If the people are being irresponsible, the people are the ones that need to be punished, not the dogs.
And,
Okay,
you
now
know,
that
the
leads to
first,
another question. Hunting season's coming.
I'm sorry?
Hunting season is coming.
Yep.
I have people trespassing consistently.
Mhm.
My dog's out there. It chases them. It catches them. It bites them. And it's not my dog's fault. It's doing its job.
Again, if they're on your property, that's not a problem.
I wanted that clarification.
I'm correct on that, right?
I mean, that's gonna be an issue for a judge to decide. That's an entirely civil thing, where, you know, because there's gonna be a counterclaim saying they were trespassing on my property.
Just sounds like your dog is protecting
I would make the same defense.
What?
Your dog is protecting your property.
My dog's protecting my property, me and the horses.
And that's an affirmative defense under Ag and Market.
Well, that's for the two, I mean, that's, if the owner of the dog comes and says, your dog bit my dog, then just say,
What was your dog doing on my property?
it's not your
And
fault.
trust me,
Yeah.
we've had plenty of times where the cat has taken out the dog.
And Debbie, that's really the same answer for your question, is
Our barn cat.
we can't,
Oh, the dog that came.
it's gonna tread into a zoning issue if you're requiring fencing around certain types of property and kennels. It's gonna be a lot. In essence, they have to keep a dangerous dog on their property. If it leaves, it's technically running at large, and then there, again, if something occurs, there's remedies in the law for it.
Yeah, that was a follow-up to the question I was just going to ask, going back to what I
It'd be
said,
quick.
okay? I don't care how well-trained a dog is. I don't care if it's an obedience champion, a hunting dog, a show dog, whatever. If that dog wants to go after something, it's gonna go. I don't care how trained it is. What I'm referring to is if you have a dog that's been deemed dangerous and you're out on your property with the dog and the dog is running loose and it takes off after something or someone off of your property and bites somebody, that's my concern.
I mean, the reality of the situation is, we can put the laws in place. That's about all we can do. I mean, I don't know if I'm dating myself here, but if anybody's seen Minority Report, the Tom Cruise movie where they're prosecuting people for potential future crimes, I mean, it's still America, we don't do that here. The unfortunate reality of the situation is, can't do anything until something happens, and I get the point that you're making, that by then it's too late, something's already happened,
Right.
but
Right.
that's the reality of it.
Well, that's the reason for this law, is to try to stop stuff before it happens.
Right, right.
Because
The owner
that
returns.
not only protects the owner, the person or animal who gets bit, but it
Right.
also protects the dog.
Right.
It's like, they're a dog, they may not be a good reason that, oh, I shouldn't do this. I shouldn't do
Right.
that. If there's a problem or whatever, then let's try to anticipate that and make sure it doesn't happen, because nobody wants to see an animal potentially in a court order to euthanize.
Right, exactly, no, I agree, I just, like I say, my only reference was with regard to dangerous dogs and the fact that regardless of what training any dog has, there's gonna be that time that it's not gonna care how many times it's been trained to stay or whatever. There's a
So,
possibility.
I had a question up
How
front
is
here,
a dog deemed dangerous? Like,
Legal
like how-
process. A
okay,
judge.
but that's what I'm saying, so like, someone trespasses and the dog bites and then, oh, the dog's dangerous,
No,
like,
so it's a
that's-
formal judicial hearing. So let's do a hypothetical here. So my dog gets out and goes over to Taylor's house and bites her. Taylor can call the dog control officer, or she can go and file a complaint with the court herself. Either a dog officer can come, take a sworn statement under oath, or Taylor can go to the court and make a sworn statement under oath to the judge. The judge has to determine, based on the evidence that was put in front of him, whether there's and again, it's not a guilt or innocence determination, whether there's probable cause to believe that the dog may be dangerous. If the judge believes the dog may be dangerous, they have to issue a seizure order and have the animal control officer seize the dog. If the dog gets seized within 5 days, there has to be a trial essentially to determine by preponderance of the evidence as the civil standard whether that dog is dangerous. Actually, I think we may have raised that to clear and convincing evidence. Let me be clear on that. So we use clear and convincing evidence, which is a higher burden of proof than preponderance. If the judge decides that under whichever section of the law the complaint is brought under, that the allegations are founded, just like it would be in any other court proceeding, criminal, civil, or otherwise, they will deem the